Charles, if you can make me a participant as well.
Yes, I can. There you go. And Ben, the show is yours. Okay. I'll go dark.
There it goes. Okay, fantastic. Okay. Can you guys see the video, the presentation, the PowerPoint?
Yes.
Yes.
Okay, perfect. Yeah, so like Charles said, we bring these seminars twice a month, and our goal is to really make healthcare administrators and in-house legal counsel smarter, more astute, more in tune with the nuances that they haven't thought about in a while, or just make them a bit sharper at what they do. And with that, as I prepare this stuff, I get sharper about it too, and it brings back some memories of the history of what I've seen over the last 20 years. And it's our way of actually contributing back to the healthcare community, and as well as raising a level of awareness and business that goes hand in hand with it. So with that said, I'm going to start the slideshow and from the beginning. Okay. So we are healthcare law partners. Our website is healthcareattorney.net. Today, our topic is how to navigate through litigation for in-house counsels and administrators. We called it a civil action, like in that John Travolta movie, but because I thought it was a catchy name, but I think it was a faux pas on my part. But anyway, it's how to navigate through litigation. Just so you know, as a matter of, Charles, are we recording this? Yeah. Is it on?
Yes, you are. This is being recorded, yes.
Okay, perfect. So this presentation is intended for general information and educational session. It is not legal advice. This seminar is open and live and being recorded to be used on an open platform as an online resources for viewers. So with that said, I'm gonna walk you through a couple of different scenarios that I think will give you the essence of what we're about to go through. Have you ever wondered like how to call someone's bluff when they threaten you with a lawsuit, or do they really even know what they're talking about when they actually threaten you with a lawsuit? I just recently something came to mind. I had my landscaper guy introduce me to one of his cousins who's also a landscaper. And with that, the guy was owed about $5,000 from a property owner, and so I sent over a demand letter just out of niceness. I wasn't charging anything. I was just like doing it out of niceness. Poor guy, he worked his tail off, invested all this money in like planting trees and sod and all that sort of stuff, but never got paid on it. So I send over a letter to the property owner, and I say, hey, can you please pay up this roughly a $2,000 balance that's left? And the guy goes off completely. He starts screaming at me on the phone. And I basically said, hey, I got to hang up. Then he calls me back and starts leaving me messages on my voicemail, basically saying, I am super good at litigation. I am a super litigator. I will see you in court, my friend. And he's going down this tirade of just like obnoxiousness, when all I'm trying to do is get this guy paid his $2,000. So as I realized who my adversary was in this case, which number one, he said, let's go to court. He said, I'm a super litigator. I'm super strong in litigation. That told me that he had never litigated before. That was very clear just by the way he said that and what he said. All I knew is that he was just a crazy nut, right? So that I could certify, but I also knew that he was not a great litigator or had ever really been in court. So what I did is I looked him up, I filed a lien, and 10 days later, in came a check for my landscaper. So that's what's called essentially knowing your adversaries and knowing when to chase them and knowing how to go about it and pressing the right buttons. But you also want to make sure that you call them on their bluff, because filing that lien called them on their bluff, and he had to pay up. I'll give you another scenario. There was a healthcare receivable that was worth about $375,000, but in the contract itself, it did not have PPAF, prevailing party attorney fee provision, and it came without it. So when I started that dispute, what happened there was it was $375,000, but we ended up settling it. We ended up settling it for $325,000. And that was a $50,000 haircut, primarily because there was no prevailing party attorney fee clause. Otherwise, I think we would have pursued it for the full amount or virtually the full amount. And that was another great settlement. In another scenario, we had where there was a national organization that hired a medical director locally and owed this medical director roughly about $4,000 a month. And it ended up being about a $25,000 bill. And they just did not pay this medical director what she was owed. And, in her contract, there was prevailing party attorney fee clause. And we settled that one for exactly the same dollar amount as what was owed. And the difference was the prevailing party attorney fee. So when people tell you, hey, when people are bluffing you, you got to really think through what you have in hand and what kinds of things you can incorporate to go after them, to defend yourself on both sides. So that's what today's session is about. I think it makes business administrators better at what they do. So here's a little bit about us. My name is Ben Assad Mirza. I am a former CPA. I have been practicing law for almost 20 years. In April, it'll be 20 years. And I have several degrees. One of them happens to be a master's of public health. And that degree I primarily got because I saw that there was a gap between attorneys and healthcare providers and administrators. So it's almost like a triangle, which is also what our logo is. It's essentially a triangle that no one person understands all sides of that triangle. And so it is our goal to actually bring as comprehensive of an approach as we possibly can. And so with that, I actually obtained a master's of public health degree, just to understand that sector better, understand what the providers were thinking, what the administrators were thinking. And today I'll be joined shortly by my colleague Ed Meyer. Ed Meyer is the Yoda of healthcare. He has been involved in healthcare laws since the 1980s, since the Reagan administration. And he is fantastic. He is my go-to guy. If there's something in healthcare law that I cannot figure out on my own, I will go to him first. And, healthcare is a very vast field. Then last but not least is Komal Mirza, and she is my niece as well as an attorney. And she is our associate. She is the one person that's been practicing less than a decade, obviously. She's been practicing about 4 years. And she's on vacation today, so she's not on this video. But here we go. So this is where we start off. We always start off our videos or our seminars with market forces. Like, why are we here? What are we doing today? And how are we going to navigate the space? So what you want to understand is lawsuits impact your business. They impact the effectiveness and the efficiency. So the number of lawsuits that show up against an organization tells you how ineffective or how bad they are at resolving their conflicts with outsiders. The worse they are, the more lawsuits they will have. And all lawsuits cost significantly in time and money. It's not just money that you pay out for legal fees, but it's also internal staff time. And it detracts from the energy and the strategy of the business. But nonetheless, they're important and they're a way of life. And this is just the way things go. Public opinion also matters in this case. In the healthcare industry, public opinion is so important that I cannot state it enough. From anywhere from bond underwriters or security underwriters that will look at what you have out there pending as litigation, to actual patients that come to your business. Their opinion matters, and how you are portrayed in the newspaper makes a difference. So whenever I counsel my clients regarding a lawsuit, we also talk about the public side of the opinion. Do we need to do anything there? And we navigate through that, making sure that it's done the right way. So our goal here today for you is to make you smart at litigation, not necessarily make you litigators, but understand when to hold them, when to fold them. So understanding when to take on a challenge and when to bow out of it. Today's presentation is roughly going to be, I'm going to try to shorten it to about 40 minutes because we're going to be short on time a bit, but we're going to talk about in generalities, the types of different lawsuits that are there. We're going to talk about the pleadings that are involved and the types of cases, affirmative defenses, and the timeline. Line item number 4 is probably the summit of the entire understanding here that we're going to go through. And if I can get to that slide, that's a slide that I want to spend the most amount of time on. And I'll give you a prelude to it. It looks like this. You see, there's the orange sections here, and then there are the blue sections here. We're going to touch on those and how the orange is different than the blue. Then down below, we're going to talk about costs, what to expect in terms of costs. And we're going to talk about what makes a case complex or simple. And I'll get you to this end slide in the end, but I've got to work you right through the basic complexities of how lawsuits take place.
This is Ed Meyer. I'm sorry, I ran a little late.
Hey Ed, welcome.
One real good point is keep that slide in your file, because that's going to tell you over time, how things are going to be developing in these lawsuits and how costs align and where potential settlement potentials are. So that slide always in your file.
So Ed Meyer is the Jedi I was telling you about, the Jedi of healthcare, and he's a great soul. So we work well together. We work on clients together. So anyway, so there's actually 3 different types of lawsuits that'll take place. There's criminal, there's civil, and there's administrative. Today, our focus is only going to be on the civil aspects of lawsuits. And then Janae may be able to relate to this. Under torts, there's generally what's called negligence claims, and they often carry punitive damages with them, and a certain amount of incalculable damages that are opined on and assessed. So in negligence claims, you will have things like failures to do something that the other party was responsible for. Like you could have like a failure to respond to a call, failure to diagnose a person properly, a delay in treatment, failure to read orders or read diagnostics tests. Can you imagine in a practice where if the system is not uploading the diagnostics tests and the physicians are not getting a chance to read it, what that can cause to a practice and the patients? That would all fall under the torts realm. So today, although we focus primarily on contracts, we're going to be talking about a breach of contract. So breach of contract usually happens in 2 ways. It's either a breach of payment or a breach of performance. And one of the niches that we practice in the area of is going after healthcare plans and reimbursements. So these are the different types of lawsuits you're going to get presented with. There's also what's called a quantum meruit lawsuit. Quantum meruit is essentially fulfilling a promise that you promised to do do something for somebody, but were never acknowledged and reimbursed for it, right? So first you did it, but then you never got reimbursed for it. Depending on what area of law you're in, you're going to want to pick the right attorney for that practice area. Like there's people that do negligence and negligence claims, and that's all they do. Then you have people that do contracts and contract breaches, and that's all they do. We fall more towards the contract breaches, although we do get involved in negligence claims from time to time. So these are the 2 areas of law we're going to touch on. So let's start off with the pre-suit litigation strategy. The reason why you see this tiger's picture in here is, as a tiger gets prepared to hunt a deer or a gazelle or a bird, it goes through a whole calculation, a calculus in its head as to how it's going to pursue it, how it's going to get there, what its foe looks like, and whether there's a meal at the end of it that's worth satisfying. And in the same way, I don't think that we, in general, spend enough time in doing this pre-suit litigation calculus. There's got to be a lot of time that's spent on this, and it's not a lot of time in terms of actual time, but we've got to just give it the respect and the time that it's due, that it's owed. And what I mean by that is, number one, I always want to know what my damages are. Whenever two parties are disputing, I want to know what the amount of the damages is. Like we were talking about earlier, there was a $2,000 scenario with that landscaper, right? And then there was a $25,000 scenario, and then there was a $350,000 scenario. So which one are you going to really litigate over $2,000? And the answer is no, you're not. You're not going to go and hire an attorney over that. However, if there's prevailing party attorney's fees, it changes the balance of the game. So you want to look at your damages and how these things interrelate. So in the same way, the tiger does a calculus for a deer, you want to do the calculus for what it takes to go against your adversary. And you could be on the plaintiff side of it, or you could be on the defending side of it, depending on how, what the deal is. You want to take a look at the breach. Where did the breach occur? That will often determine where you're going to be litigating, unless if it's specifically stated in your contract, which is exactly where I like to see it, is in your contract. Where will you file that lawsuit? That will determine the venue. And then before you actually institute a lawsuit, I also like to understand what the insurance coverage provisions are in those contracts. Those provisions become really key. So those of you who are attorneys on this in-house attorneys included, please do read the insurance coverage provisions inside the contracts, because they will determine whether you can invoke maybe some sort of a negligence claim into this and make your client whole. The next thing that I'm also looking for is PPAF, right? The prevailing party attorney's fees. The prevailing party attorney's fees is a really important clause. That makes a difference between whether you take a $25,000 claim and litigate it to the ends of the earth, or do you take a $375,000 claim and pull it back and settle for $325,000.
Or if on the other side of the I'm going to say, or if you're the other side of your other side of the coin, whether you're going to be, if you have a weak case and you're this, you keep running out a weak case, whether you're going to end up having to pay the attorney's fees on the other side. So you just got to balance all that out. That's an important strategy, or early strategies decision.
And then once you've gotten these clauses under your belt and gotten a understanding of it, then I always have my clients think about what is the best case scenario. What is the best case scenario if tomorrow the court gives you exactly what you want, and what would that be? First, articulate it for me. Tell me if it's money. Tell me if it's making you whole in some other way. Telling me if it's stopping somebody from doing something. And then what you want to do is you want to assess whether, let's say the court gives you a $350,000 judgment. Does that party have the ability to pay you? Again, it's like getting a $350,000 judgment or a 50-pound judgment against a sparrow versus a deer, right? So a tiger will chase a deer, but will a tiger chase a sparrow? It's not the same payoff, right? You got to make sure that they've got enough money to pay you that's worth chasing, because that's your best case scenario working out your way. Then the opposite side of it is you want to take a look at your worst case scenario. What is your fallback position? What if things don't go the way you thought that they would go? What if the other side starts raising claims against you yourself? What kind of risk or exposure are you in? And you got to balance that out. Once you've gotten this lay of the land, then what you do is you go back and you look at it holistically again. You re-review your insurance coverage, you re-review prevailing party attorney's fees, you re-review like the whole scenario with your client, and you figure out, like, is this a road that I'm going to go down on? The last but not least I wanted to point out to you is there are certain lawsuits filed as a part of a market strategy to either stall or accelerate an outcome. So what I mean by that is certain companies will get into litigation to stall out their competition from doing something in the marketplace. And conversely, they will also help do a pile-on to help them accelerate their demise. So those cases do happen from time to time, and we help our clients think through that. Ed, anything else you want to add to this particular?
No, and again, just keeping the big picture, you're basically deciding whether or not this is actually go to litigation or not, whether or not it's worthwhile to go to litigation. And if it is worthwhile to go to litigation, then when and you're going to get this in a section, before you even get to the actual filing of things, there's a series of demand letters, cease and desist letters, and things like that. And we have in-house counsel here, and keep in mind that obviously, if this is turned over to litigation counsel, outside litigation counsel, that litigation counsel is going to want to do their own set of demands and do it in a manner that focuses their case in the most efficient way. So you're also deciding at what point can this be this letter writing that goes on before, demand letters that go on before, cease and desist letters before. To what point is it turned over to outside counsel who is really going to have to handle the case as it goes? Because in-house counsel is just not efficient for in-house counsel to be litigating and spending the time, though they're coordinating obviously with outside counsel on it, because all this, as we know, is you're going to see throughout, it takes a lot of time and a lot of effort from executives once you start going down the path of actually having filed a formal complaint.
So like Ed said, before you get started, what you have to do is you have to get your facts together, and you got to get demand letter 1 and demand letter 2 out. Once you do those 2 demand letters, then you've essentially set the stage. And although in-house folks will often start off their own demand letters, as an outside attorney, majority of the time, I will resend those demand letters in a really nice sort of a way where it's very clear exactly what clauses we're relying on, exactly what breaches there are, so it makes our complaint and our lawsuit a lot cleaner. So typically we'll send out a demand letter 1 and a demand letter 2. If they don't respond after the demand letter 1 from an attorney, then it's demand letter 2, and then the second letter is saying, look, either fix it now or deem this contract terminated. Every now and then, depending on the circumstances, there might even be a demand letter number 3, but we try to keep it within the 2, depending on the circumstances. So then what happens next is you would file a complaint. And once you file the complaint, that's when the other party has to get served, and they will typically file an answer or affirmative defenses. But what a lot of attorneys do right in between complaint and the answer is they'll start filing motions to dismiss for things like your complaint is not clear enough, that it is not specific enough, or that it's missing one of the elements. With me, I personally do not file motions to dismiss. I pretty much steer clear of it unless my clients absolutely wants me to. Because the reason is, if the opposing side files a complaint and they're missing an element, a legal element to file that complaint, I don't want to tell them up front. I don't want to give them the chance to correct it. I want to take them to final judgment right on that same thing. Why would I help somebody fix something which is deficient to begin with? And I think that's a mistake that's often done out there by the younger attorneys, but the more seasoned attorneys don't do motions to dismiss unless there's a very specific and sort of a reason. The next thing that happens is after the complaint has been filed, there's an answer and affirmative defenses. Then there's what's called discovery. The discovery is the request for production of documents, which is when the one side asks the other side, send me all of your documents as they relate to this controversy. Next thing they will ask for is interrogatory. So each side has the ability to ask general questions. Hey, what is your basis for taking up a particular defense? What is your basis for bringing forth a specific count in your complaint? So, and they're looking for factual basis. They're not looking for legal basis. They're really looking for the facts that are supporting that position. So that's a second form of discovery. The third form of discovery is actually depositions. Request for admissions, and then there's actually depositions. So there's 4 forms that you'll take on, and then the third form, the request for admissions, is a lot shorter. It's quick, but it's very specific and narrow. It's pled much like the pleadings. And last but not least, there's also depositions that take place. If one side doesn't answer the other side, then you have to do what's called a motion to compel discovery, to push the other side into providing the discovery requests that were sent out. As this is all going on, what my general strategy is, file a motion for summary judgment. As soon as I've got enough discovery, what I want to do is I want to file a motion for summary judgment and put it into the courthouse. Put it, place it there. So now it's actually a placeholder and pending. And now what the word motion means is a request to the judge for summary judgment, a request to the judge to compel discovery. So think of the word motion as a request to the judge. Okay, so in a motion for summary judgment, I like to have it sitting out there pending. And then what I like to do is I like to have people go to mediation. Because, so for example, I'll have them go to mediation in March, but I will have my motion for summary judgment already filed in February. And I'll schedule it for April. So you either settle at mediation or we're going to court on the motion for summary judgment in front of the judge.
What you've done through the discovery phase is throw out the facts, because your clients could be coming to you, to the in-house counsel and then to outside counsel and saying, this is what they understand the facts are. This is what they have. But there's obviously two sides to the story, right? And you want to see what the other side has to say and what were the strengths or weaknesses of their point. And then to use that set of information where you're well defining what facts are out there and what facts are not out there, so that you use that in your mediation and your attempt to settle. Again, keeping in mind as you move through the discovery phase, this is all costs. This is all costs, not just in fees, but also costs in executive time. If you're doing a deposition requiring depositions of executives, and executives have to take a day off of actually maybe even travel to the locations where these depositions are occurring, and they're away from business, they're away from effectively making money for your organization. So,
and then there's also deposition preps too that you do with your executives, right? So that's all a detractor from the main line of business. And the other thing that I want to bring on as a special note is the motion for attorney's fees. The motion for attorney's fees can only be had in really two ways. One is either by contract, so it's stated in your contract, or by statute. So, in the state of Florida, there's what's called a 57105, which is a frivolous lawsuit statute. You can actually, put the other party on notice and file a motion 57105 for attorney's fees. And, that rarely works. That one rarely works. But nonetheless, it's out there, and it's good to have as a possible threat. What is an even better one is actually what's called an offer of judgment or proposal for settlement. That's another statute where it's got really fine triggers, but it actually locks in the other side into whatever decision they make. So anyway, I won't detract from that, but if you have any questions on something that you're seeing on attorney's fees in one of your cases, call me. I'll walk you through it as to how to trigger the attorney fee statutes. The next thing is you're going to set this. Let's say you don't settle at mediation. Let's say you don't get the motion for summary judgment in your favor. You can do it again. You can repeat mediation. You can repeat a motion for summary judgment. And let's say that if they fail, then you proceed to actual trial. You'll do a motion to set the case for trial, and then you'll have either a bench trial or a jury trial. Bench trials are again evidence-based, and they're done by the judge. Jury trials require the box of the jurors, right, and then they have to decide. And then once you do finally get a judgment from the court, then there's actually post-judgment collections or an appeal. So your case can go either way. Some majority of the time it'll go towards either the one side or the other side is collecting on something, or it'll go to appeal, which is a rarity, but we appeal cases from time to time as well. So here are some litigation offenses and defenses we're going to talk about real quick. And the point of this is either you raise a litigation claim, or you use it or lose it. If you don't raise it up front, you lose the ability to use it later on. Same thing with an affirmative defense. Once you answer a complaint and you don't take up all of the defenses that were available to you, you use it or lose it. You have to create a whole other new set of circumstances for you to be able to re-invoke that later on. We've done it before, but it's a lot harder. It's a lot more work, and it's costly. So keep in mind that you're going to have, breach of contract claims, and you're going to have negligence claims. And those are, again, your contracts and your torts, right? And you're going to have different types of affirmative defenses. Like if you take a look at breach of contract claims, there's what's called abandonment of a contract. That's a nice defense. There's act of God. In this world of COVID, although COVID is not really deemed an act of God per se, people are invoking that, and some people have been very successful at it. So officially, I think the final decision is still out whether COVID-19 is deemed to be an act of God and sufficient enough for cancellation. In certain industries, it might be. In other industries, it might not be. I'm sorry, what's that, Ed?
No, I say force majeure provisions in your contract, might give you out. And obviously, what's happened in this whole COVID world is a lot of folks have been looking at their contracts and saying, well, do we have to pay on the contract if COVID is really reducing, our ability to get things, get the services, our ability to deliver the service? Are we breaching it? So that's been a significant review by a lot of folks on how because it really throws into everything a wrench of whether this was foreseeable in the first place, and whether.
The other thing to also keep in mind is if you are dealing with something that is either a disputed contract or a pending case, we do a courtesy review at no charge for our clients and prospective clients, just so they get a lay of the land and we can steer them clear of whether something is worth litigating or not worth litigating. At the end of the day, we prefer to get to the right answer than the right money-making answer, if that makes any sense to you. We will guide you to what is probably the best and most efficient solution to what you need. And many a times it's, we will steer our clients away from litigation. Here, this is this is the one slide, if I could have you walk away with, this is the one slide that I would love to get your understanding on, because I think this is what helps you do the calculus for whether you go to litigation.
Whether you go and where are the points where there are opportunities to settle, where are the opportunities to put pressure on the other side to this, et cetera. So, and also where the costs start racketing up. So,
it's good point.
It's a great timeline. It's a great timeline.
Just so you see this, I mean, if you take a look at it, there's a year one and a year two. This automatically tells you that there's going to be, if you actually go the full load, the full course of litigation from beginning to end, and you don't settle somewhere in the up front, and you don't litigate super tightly and make the other side settle into a nice situation, you're going to be in it for a 2-year haul. So just be aware of that. If you're going to litigate, think of it as a 2-year haul, unless if you can pressure the other side into succumbing to your demands. If you look to the lower left, that's our cost matrix. That is the fees as to what we see with our firm when clients have us litigate. There's actually different degrees of complexity of cases. There's like a low, medium, high, and then there's like an extreme. And majority of the cases fall under either a low level or a medium level of intensity. And those have their fees and costs associated with it. A low level of intensity case is something fairly black and white, like an invoice that's due, not a whole lot of complexities to it. That sort of stuff runs you about $1,000 a month of like attorney's fees. But if you have something a little bit more complex, like breach of performance or failure to perform, that's going to cost a bit more because it gets a lot more evidence based. So if you look to the right over here where it says estimated fees is a function of the number of adversaries that you have. So it's like how many people are you fighting at the same time that are directly opposed to your position. So you got to take a look. You could have, I've seen lawsuits where you have 20 parties, but there's actually only one person on the other side that's actually opposing my client's position. That's again a low level of adversaries because it's only one person, even though there's 20 parties in the case. There's also the complexity of the legal matter or the subject matter. How complex is it? Is it an area of law that's hard to understand? Is it an area of fact that's hard to understand? And then when it pertains to the facts, how easily is the evidence available? Can you get ready evidence? Like, for example, for a breach of contract having to do with failure to pay is really black and white. You can have invoices, you can show the work and timesheets. That's easy. That's easy evidence. But now let's say if you have a lawsuit against slander or libel, the evidence for that is very different and it's a lot harder to gather. So it raises the complexity of it, right? That's how you have to look at these functions. The last but not least, you also have to look at the propensity to litigate. What is each party's propensity to litigate? You know, some people will litigate over just about anything. I've seen people litigate over a $500 item back and forth, and they'll spend $10,000 of fees on a $500 item. So what's the propensity? What's the logic, the common sense that's going into it? And what's your end goal? So the propensity to litigate adds to that. So once you kind of get a feel for this, then you can figure out whether your case has a low, medium, or a high level of complexity. You know, majority of the cases are, again, a low and medium level of complexity. There aren't that many that go to the higher levels of complexity. And then there's the extreme cases, and, you know, the extreme cases turn into like the class action suits and you know, like the False Claims Act, that sort of stuff. Those are high level of complexity, and they will be super expensive. So here is a timeline. So let's start going through the timeline. If you understand this, you'll know whether the person on the other side is bluffing or whether you should be heeding their warning. So this orange part here is pre-suit work that you have to do. First is you put the other party on notice of the breach. So that's your demand letter one that goes out, and you ask them to fix that breach. So this January 01 is the first notice that you send over to the other side. The second notice, let's say that they don't do anything and they don't fix it, or that they try to fix it, but it's done the wrong way. Then you send them a second notice. And that's when you actually tell them, look, I'm going to terminate this contract if this is not, because either it hasn't been fixed, or I'm actually terminating it, or it needs to be fixed within a 5 or a 10-day period, or else it's deem it terminated. So that's where by that time, you're already in March, if you actually think about this. By the time you terminate the contract, 2 months have already gone by. And this is a normal sort of a scenario. You're not talking about something, I'm not exaggerating, and I am not oversimplifying. This is very normal. The other thing that you're going to do is you want to get all of your documents, and you want to do your own internal investigation, and you want to pull them together, and you want to research who your opposition is. So like if you see over here, April and May, I'm actually researching the opposite side. I want to know whether I'm dealing with a sparrow or a deer or a bear, for that matter. So in the same way, you're going to assess the other side. You want to see who they use as legal counsel. You want to know whether even the attorneys that they use, because there's different attorneys have different styles. Like, you know, you get familiar with different people's pleadings and things and how you've seen them. If somebody's been practicing for a while, they may have an idea of what the opposing counsel is like. So this right here, this 4th month, is where you're going to make sure that you get that assessed the right way. Now, you do want to try to do this as early in the stage as possible, but April is absolutely your last month. Then come May, you want to now prepare the lawsuit and you want to get it served, right? So once you serve it and you you hand it over to a server, and the server is going to take 5 to 10 days to actually deliver it. Then the opposing side has another 20 days from the date of service. So that there goes another month. So you're already looking at now 6 months into it. Then they start to do certain preliminary motions, motion to dismiss, motion to strike, et cetera, et cetera. And these are called this is called motion practice in litigation. That takes place, and then they'll eventually file an answer. So by that time, you're looking at roughly July, okay? you're going to want to take discovery during this time frame. Between July and September, you're going to want to take discovery. You're going to start sending out your request for production. You're going to start sending out your request for admissions, request for interrogatories, or propound the interrogatories. And then if they're not responding to your request, then what you want to do is you want to start filing motions to compel the other side, to push them to answering your discovery requests. And conversely, they could be doing that to you because you may be non-responsive. You may be avoiding their questions, and you've got to answer them sufficiently enough so you avoid that motion practice. Again, you can litigate as much as you want to. You can litigate for every single little line item, or you can go for the bigger picture, which is generally my style, is go for the bigger picture. And I think clients like that. I think it works well to the efficiencies of litigation. And that's how you do that. So then what you also want to do is you want to start doing depositions. There's going to be 3 different types of depositions, as you can see here. So you're going to have a deposition for the facts. So like if there's a nurse on the floor that saw something happen to a particular patient, she is a fact witness. She will be, or he will be, witnessing what happened to that patient. And then you want to depose that person to make sure that you can get their insights to it, because through deposition you will find things that you did not know about ahead of time. The second thing that you want to look at is who is what sorts of equipment, premises, reports, systems are in play that you have regular inspections taking place. So you want to involve those people who are responsible for maintaining the systems that support that service. So that's what I call like deposing the inspectors. So like, for example, if you have a blood pressure monitoring machine, right? Is there anybody inside the practice that regularly inspects the actual blood pressure monitoring machines? If they do, you want to take their deposition. You want to find out, hey, did you actually inspect this? When was the last time you inspected it? Did you inspect it 3 months ago or 3 years ago? You know, although they may not be a fact witness to your particular situation, they may know things about the things that caused that failure to occur. Last but not least, the third type of deponent you're going to have is an expert. An expert is usually an outside consultant that says that A plus B equals C. And they're the ones that bring together the whole story. They will take the picture of what the nurse saw, what the inspector saw, what happened to the patient, and then draw a picture for the judge and jury. That's your third. Now, remember, you don't ever depose any of your own people. You don't ever depose your own witnesses. You don't ever depose your own expert. You only depose the people on the other side. Okay? So when you do this and you've gathered up all the evidence, then what you do is you file you request mediation. You go to mediation and you file a motion for summary judgments almost simultaneously. So you file a motion for summary judgment, set it for a hearing a couple of months out, but before that hearing, you want to have your mediation. And that's where both sides meet with their attorney and a mediator in the middle. And the mediator in the middle will help each side understand the other side's story. And at the mediation, you want to have some sort of a pushing motion sitting out there so you can push the other side into deciding today if today is the best day to settle. And when I mediate, I always start off with the opposing side saying, today is your best day to settle. And I'll tell you why. Because if we don't settle today, we are proceeding to court. And if we don't settle it there, we're proceeding to trial. And I'll tell you this, 99% of my cases settle either at the mediation stage or at the motion for summary judgment stage. There's very few that actually go to even a bench trial and forget about a jury trial. That's almost a never. But if it does happen, you know, you got to get the right counsels on for that. So anyway, so this is the lay of the land for that. Right now we are up to this mediation. Oops, sorry, going back. We're up to February 02, where you're in mediation, okay? After that, if you do not settle there, again, it's going to take you about a year to literally hard press the other side into a settlement. But if you don't settle there, you're going to end up going to motion for summary judgment, and you're going to have what's called dispositive motion. Dispositive motion is a hearing on the merits of the case. If there is nothing at issue and you can find things that are not at issue, meaning that are not factually disputed, you can actually have what's called a motion for summary judgment and have those things heard. And if the judge says, sorry, there's too many gray facts here, I cannot determine this, then you actually have to go to trial. So what you do then is you do a motion to set the case for trial. In the meantime, you want to make sure you gather up all of your last bit of evidence, and you want to organize all of that evidence into the right categories, into the right directories, into the right files. And you can have boxes which often replicate what you have on the server as a PDF document. And you will have deposition transcripts that are all going to flow with that, and you will proceed to trial. So what happens here is the majority of the cases will fall between a low, medium, and a high. If you ever go to trial, you've entered the extreme. Entering the extreme, you can see a case, a medium level of complexity of a case that goes to trial and hits $75,000 of just trial-related fees, meaning preparing for the trial and actually going to trial. So you want to avoid trial as much as possible. You want to push the other side into settling. If you have a lawsuit that's been sitting out there for a year or 2 years and not a whole lot of movement is going on every month, this serves as your checklist. This calendar here, year 1 and year 2, serves as your checklist to talk to your attorney to find out, where are you in this process? Tell me what you're doing. Tell me what I can do to help. And this becomes your 24-point checklist. So use it for that. And if you have any questions, send over the actual disputed contract or the case to us, and we will review it at no charge. Ed, anything else you want to add to this slide?
No, and again, that slide really tells you, one, is your attorney, communicating with you effectively because they telling you where you are. 2, where are your costs? Where are your high costs? Where's your high costs in fees, and where are your high costs in time? And and 3, at what point do you know enough facts to actually try to settle it efficiently, or what facts you go really your case is not as strong as you need to, as you would hope to be, because there's facts you didn't know about. Because again, keep in mind, your client might not know the whole story, maybe not telling you the whole story, or maybe not thinking a fact that you should have. They might not think it's important because they don't know the law, the actual law that you're going to be applying. And again, as attorneys, we take facts and apply them to the law, and then come out with the supposedly the answer. But I guess like I said at the very beginning, this is a slide you should just have up. And if as you go through a process, knowing that litigation process, this is where it's going to cost you, it's where times, and this is where the pressure points for settlement are. And again, if you get to court, if you end up for a trier effect, especially if it's a jury, you just do not know where it's going to be. And as counsel, we have to take the emotion out of the client, take the emotional piece out and advise our clients effectively what their prospects are.
And Ed, that's a really good point. There's attorneys that actually fan the flames of emotions.
Yeah, I've seen that. Yeah.
And you want to steer clear of that as much as possible. You don't want an attorney that's overly relaxed or overly fearful, because both will work against you. So you want somebody that's tightly wound, but at the same time relaxed. Yeah. That makes any sense.
I'm not a litigator. Ben's a litigator, so I'm there to discuss with the in-house counsel and deal or assist Ben, and I'm looking especially in the federal law area. That's what I handle. Yeah.
Thanks. So then when it comes to these cases, majority of them will settle either April of 01 or April of 02. You're either settling on the 4th month just into your dispute just before you file a lawsuit, or you're settling upon either mediation or dispositive motions. So you're either looking at resolving it either really early on within the first few months, or plan for a year-long battle after that. Right. So think of your lawsuit in those ways. This orange part is one part. This second part here, this blue, up to this April 02 is where majority of your lawsuits will settle. This latter part, starting in basically trial and trial dates and so forth, that's again the 5% chance that you're going to go down that road. But majority of your stuff is going to get handled right up to here, the April 02 mark. So with that said, if you have any questions on that, please do either call me or email me. And I'm going to touch on this last slide.
Last minute we have, yeah. Absolutely.
Yeah, we just have another minute or so left. This, a lot of businesses, their profitability is their assessment of how profitable, efficient, effective they are. So the litmus test for efficiency is collections. The U.S. healthcare is nearly a $4 trillion business. Those entities that are able to collect the cash and keep the profitability are the more successful ones. So what we're also finding in this environment, as the whole healthcare sector moves more towards value-based care arrangements, so like ACOs, the MCOs, the accountable care organizations, the managed care organizations, the sharing of risks becomes a part of our healthcare business. More and more, the healthcare plans and payors are denying reimbursements, and they base them on several different areas. It could be, for failure to document, not showing the medical necessity, not getting the pre-approvals that were required, etc. They have, about a dozen reasons as to why they will deny payment. But what we do uniquely is we actually take on these cases on a contingency fee basis, not an hourly fee basis. And we will resolve these cases in two ways. One, either before litigation, and if we do it before litigation, our contingency fee on it is roughly around 20%. It varies depending on the dollar volume that's at issue. Or it's done with litigation, and then that's either a 60-40 split. And that ends up being really valuable to our clients because then they're able to settle out these matters in a nice way without risking anything, without risking any attorney's fees that they would have to pay out to us. So with that said, we are healthcare law partners. If you are dealing with a legal contract or a dispute and you have any questions, please call or email us, send us your key documents, and we will, and ask us for a legal fee estimate. And to the extent that we can give you a legal fee estimate, we will, and you can get your issues resolved. So that's us. Thank you again for joining.
Great. I have a little bit of an issue with my camera, so you can see my background, but you can't see me, so go figure. But it's actually better the background than with me. So let me go ahead and let me see if I can switch that real quick. It won't let me, so we're a little stalled.
You stop recording, Charles, maybe that?
Yeah, maybe. I don't know. Let me see. Let me stop the recording here.
As long as you're not a cat, right?
That's right. Exactly. Yeah, we got a little issue here with stalling. So let me see if I can get that out of here.
So that's it. If anybody has any questions, you guys are welcome to ask now or contact us separately. That's it, guys.
So I kind of wrap this up.
Our next seminar. Our next seminar is coming up.
Go ahead, Ben.
Yeah, hold on. Let me just pull that up. 1 second. Our next seminar is on the first Tuesday of April, and that is on telehealth. It's on telehealth, do's and don'ts of telehealth, and the legal environment and how it's changed in the last year. So I think get ready for telehealth or navigate more smartly.
So I think that'll be a very, very good one. And we look forward to seeing everybody then. Ben will go ahead and give me a copy of the PowerPoint, and we'll go ahead and get that out to everybody who registered for the event. And we hope to see you next time. Thanks for coming.
Thank you, guys.
Thank you.
Okay. Bye-bye.
Bye-bye.